Efforts to decriminalize psilocybin, the psychoactive compound in magic mushrooms, have been happening nationwide, passing locally in Denver and Oakland, and looking likely to pass in DC and Oregon. This legislation, however, is at odds with federal law that classifies psilocybin as a Schedule I substance, which means it is without any medical value. This tension between the local and federal law recently came to a head in the case of Cole Milner, a 28-year-old Denver resident who has been charged with 1 count of possession with intent to distribute psilocybin by prosecutors with the U.S. Attorney's Office for the District of Colorado. If convicted, Milner faces up to 20 years in prison and a $1 million fine. Milner has denied the charge. This is happening right now in Denver, where many people are thinking, aren't magic mushrooms legal? So today, to help us better understand how local decriminalization measures interface with federal laws, we are talking with David Holland, an attorney with an extensive background in civil and criminal litigation and related matters in the cannabis industry. David spent more than a decade as counsel to High Times Magazine and is both the executive and legal director of Empire State NORML. David, thank you so much for joining us.
Thanks so much for the opportunity to join you.
David, please help us understand what is going on here. When a local authority passes a law to decriminalize a substance, but it remains banned by the federal government, are people protected from federal prosecution?
You know, it's a great question because pretty much everybody is confused by this. And the short answer is no, people are not at all protected from the federal law. And there's a little bit of a background that you have to understand is this actually comes out of the United States Constitution, where it says that federal law is supposed to be the supreme law of the land. So if there's a state or a local ordinance or law that gets passed, like this with psilocybin, that says that while they're decriminalizing psilocybin on the local level, that has no impact whatsoever on the federal government because the federal law is supposed to reign supreme and invalidate any local or state determinations with regard to that. And it's a really complex thing because you see this happen with the cannabis space, where 33 states have legalized adult use or medical use, and yet that's also a Schedule I drug, which theoretically under that schedule says it has no medical value, it can't be researched in a reliable way, and it has a high risk of addiction and other issues for those that are the patients or consumers of it. So in the long and short is the federal government is free to do what they want to do despite any state or local law that decriminalize. And that unfortunately is what this gentleman is finding himself stuck in that position now.
Just to be absolutely clear, with federal law as the law of the land, when something passes statewide, federal law enforcement always has the power to completely disregard it, correct?
That's absolutely right. Remember, we're a union of states. And so within the word union is uniformity. So the idea was that while the states can, they're supposed to be the laboratories of democracy, there are certain rules that need to be applied across all 50 states to keep it uniform. And this happens to be under the Controlled Substances Act, which is the congressional federal act by which psilocybin and cannabis are regulated. But that being said, I think you're going to see fewer raids when it comes to things like psilocybin and certainly with cannabis. As society grows to accept that it's not, ripping away at the moral fabric of society, as that happens, you'll start to see a change on the federal level too.
That's optimistic. Hooray. I like hearing optimism from lawyers. Great. Okay, so how do you expect the Cole Milner case in Denver to play out?
It's a tough one. There is a case called U.S. versus Chapman. And Chapman was a case that involved liquid LSD. And in that case, the United States Supreme Court said, it's not just the weight of the amount of LSD the person has, but it's the medium in which the LSD is found that also gets counted towards how much that person is found to have possessed. To give you an example, in Chapman's case, there were, it was maybe 2.2 or 3 micrograms of LSD that were dropped onto and dried out in sugar cubes. But he had that in like 50 or 60 sugar cubes, and the weight of the 50 or 60 sugar cubes pushed it to him being eligible for a life sentence. What unfortunately is going to be Cole's problem is that the weight of the dried mushrooms that he had, which was 20 or 30 grams, as I recall, and he had live mushrooms as well, all that gets put together, and let's say that weighs a pound, I'm surprised he's only looking at 20 years. That could get you a life sentence under the federal law. But again, things are changing. And so you may see the nature and how it's prosecuted and what the sentencing guidelines for that would be may change in accordance with how society's views change.
And what words of advice do you have for any other Cole Milners in the world, folks that plan to abide by state laws, not federal? How can people protect themselves?
Well, if you're going to be a loud and proud advocate, do you understand that sometimes that can come at a price? My words to people are, when you're dealing with something in the psychedelic world, keep in mind the overall weight of, while the drug itself may weigh nothing, what it's found in. And I've seen it happen with a guy that had it in a heavy lead crystal glass, even though he had 2 hits, which was infinitesimally small. The weight of the lead glass was making him look at a 20-year sentence. So be careful how you choose to store it, should you have it. That's the best advice I can give it to you.
Thank you so much for joining us, David.
Thank you for this opportunity.